Hello, everyone. Nice to see you again. What we're going to be covering in this episode is what happens when we get into the hearing room. So, if we can just get some explanation as to what to expect, who's there, what is their role, what does it look like for someone who hasn't been there yet. So, I don't know who wants to start. Let's just say, Shira, let's start with you.
Yes. So when you attend an Ontario Review Board hearing, you are accompanied, or well, the other people in the room will be the five panel members, the Crown, and you, your client, and the doctor representing the hospital. And in terms of the panel, it is made up of five people. There's the chair, an alternate chair. So there are two counsel. There's a psychiatrist member, a psychologist member, and a member of the public. And so these are all people that have experience handling these cases and the variety of backgrounds to give that experience and use that as part of their decision making process. The doctor is usually represented by themselves. They're a self-represented party. They could in theory have counsel attend on their behalf, but usually it's the doctor that is there stating the case for the hospital. And in terms of the general setup, it's essentially a boardroom. At least in Ottawa, it's set up as a boardroom with the five panel members sitting on one side of the table. Then there'll be the reporter sitting at the head of the table. And then on the opposite side is the crown, you, the lawyer, your client, and the doctor.
And sorry, how can you get information about the panel ahead of time, if it's possible?
Yeah, so you'll get a hearing schedule along with
Mhm.
the hearing documents for each hearing. And that hearing schedule, it's helpful if you have some PhD to decipher who's actually going to be on your panel because often you get like 3 to 5 lawyers and three different psychiatrists and two psychologists who are all listed as panel members. Of course, you're only going to get a few of those because then beside that is this massive list of the changes to the panel that were made with each version. We sometimes get 40 different versions of a hearing week schedule before we actually have the hearing because the hearings are set 10 months in advance or a year in advance, so things change. So if you want to know actually who's going to be in the hearing room,
Mhm.
you've got to puzzle that out, but it's going to be some combination of a bunch of people whose names are listed at the bottom of your hearing schedule. It's fascinating to hear Shira say that the doctor will represent the hospital. So at the hospitals where I mostly represent accused, that almost never happens. If one of the psychiatrists wants to represent themselves in one of these hospitals that I go to, they have to get special permission to be able to do that. And it's just a handful of doctors who are permitted to appear without a lawyer. So at our hospitals, many of them have in-house counsel, several in-house counsel who attend every single hearing, whether it's an adjournment or a consent hearing or, a restriction hearing about someone who's already long ago left hospital. So we have lawyers attending 4 hospitals at hearings where absolutely nothing is at stake. Whereas around the province, you can have a hotly contested, very difficult hearing with a physician showing up alone. You should also be mindful that at hospitals around the province, sometimes no psychiatrist shows up to testify at all. It may be an administrative person who prepares the report. So that's another regional difference. That took me a long time to figure out. Sometimes the psychiatrist is not the author of the report. It may be an admin support person who's pulled random things, seemingly random things from the clinical record and sort of copied and pasted some information together. It may be an assessing psychiatrist from somewhere else who's testifying. It may be one person testifying for the hospital and somebody else for the treatment team as the treating psychiatrist. So a lot depends on regional differences, but there will definitely be a witness for the hospital and a hospital report. And then you'll have a crown, and your crown may be someone who specializes in this area, and that's the case in Ottawa, that's the case in Toronto, or it may be a rotating series of crowns, and sometimes you get crown attorneys coming into these hearings who've never done one before, don't know anything about the area at all, but may have strong opinions on disposition recommendation anyway. So I don't know what happens, Rob, in your neck of the woods, but maybe you can enlighten us.
So one of the things I would note with respect to what happens at a hearing is there's a little bit that happens before the hearing starts. So oftentimes I'll get there a little bit before, and the Crown Attorney is there, as is the hospital lawyer and the psychiatrist. And quite frequently, there's areas of agreement where it's not what's recommended by the hospital, that together counsel can agree before the hearing that there'll be a joint recommendation for some additional terms that hopefully are to the benefit of your client. And so the short point is it's worth exploring before the hearing, and you'll get more comfortable as you uh, understand the ways of the hospital lawyer and the psychiatrist in question, what could be discussed in the Crown, and making some uh, improvement on the disposition that's being sought, because that's a good time to do it. And then similarly, um, all the uh, all the players are who have been listed, and before the hearing starts, generally the chair is the one that's kind of the master of ceremonies, and he or she will ask the respective counsel, the hospital counsel, the Crown counsel, and the NCR counsel, what their position is. And that's where it really helps you to figure out kind of what are you trying to achieve, because it's a short hearing, it's a focused hearing, and it's not the whole history per se that you're going to be discussing. It's really geared towards what are you trying to achieve from that hearing, and it's usually a fairly incremental change, or it could be a quite a extensive change. There'll be times too, like for example, when I know I'm just not going to make any headway before the hearing, talking to the Crown and the hospital, and just won't do it. Not that I'll avoid it, but just I won't go to my way to do it. And it generally, unless you are receptive to it, it won't happen. And at that point, the question is, do you reserve as to what your position is for your client, or do you set out what you're wanting to achieve? And again, it depends a little bit on the hearing and the situation, but sometimes I set out what I'm seeking, and want the board focused on a specific question. And my experience sometimes is that if you make it a broad issue, then um, the then and you don't agree to anything, and is that it sometimes works to the disadvantage of your client insofar as everybody just takes very hardened positions on everything, because nobody really knows what's at issue. So if you can get a clarity as to what the issues are and how you want to advance your position, your client's position, that sometimes helps. But that's the initial stage, and you don't have to set out your client's position with respect to at the outset of the hearing, but that's generally the starting point for the hearing.
Those are all good points, Maya, because it is a practice of this board, whatever regional location you're in, at the outset of the hearing to canvass the parties on their initial positions. Now, those positions are meant to be without prejudice positions, obviously, because you haven't heard the evidence, and at the end of the day, you may change your position. With that said, if you do change your position, sometimes they lose their mind with you. So I've certainly had, people at the end say, well, I had no notice of that. Well, we have no obligation to give notice of anything. So If you get that at the end, whether from the board or the hospital or the Crown, you say, and you want to make sure at the outset when you give your position, you should say, this is a without prejudice position subject to the evidence. But this is where we think we're going to be focusing. I agree with Rob. If you just say, I'm waiting to hear the evidence, what's going to happen is you'll get a lot of evidence about how dangerous your client is as people try to support a finding of significant threat for the threshold to keep your client under the board, when really all you want is travel passes, across Canada or into the US for 7 days. And you're going to run out of time before you can even say, do you have a problem with my client traveling to New York for a week with his family? And it's probably fine, but you might forget about it because by then they've spent an hour and a half talking about what a danger your client is just to support jurisdiction. And then even at the end, if they say, well, he can travel, everyone's going to be like, he can, but he's like so dangerous. We just spent an hour and a half on that. So you have to really think about what are the winnable things where you want to focus that you want to drill down in cross-examination. But you don't have to expressly agree to anything. So I don't suggest opening your mouth and saying, we agree my client's super dangerous. You don't have to put a fine point. You don't have to keep saying significant threat is conceded. You don't have to say that. You can just say, at this hearing, our focus is on getting these privileges added to the envelope, or our focus is getting community living. I'm looking for community living to be added to the envelope, or I'm looking for a discharge disposition with the following conditions. Then you've alerted the panel to what you want at the end of this hearing. And I think it's helpful and important to set that out. Because if you don't take a position, you either look uninstructed, which is, not impossible that you are actually uninstructed, or marginally worse than looking uninstructed, you look like you don't understand what's happening in the hearing, or you don't understand the language, or what the goal is. If you just say, I don't know. The only times that I will say I'm not taking any position at all at the outset is when I've had one of these without prejudice negotiations outside the hearing room and everyone has been horribly unreasonable. If the Crown and the hospital have been very unreasonable when I try to get them to agree to something small I want to get for the client, if I say to them, look, can we have passes to their parents' house for 72 hours and everyone says over my dead body, then I don't go into the hearing saying I'm looking for 72-hour passes because then I'm not going to help them explain why they don't want that. I just say we're going to have to hear all the evidence and then put them to the trouble of wasting their breath so that at the end I can say I'd like some passes. So a lot of it has to do with sort of dynamics and negotiations. And my approach is making people pay. So that's two different approaches you can take heading into a hearing. Um,
The other thing I'd say about at the outset of the hearing in a position is the one aspect of it is you're trying to advance a concrete objective from the disposition, and ideally, maybe it's passes, maybe it's living in the community, blah blah blah. But the other goal is to get good reasons from the board and to put the hospital from the perspective of how do you plan to get this person in the community, and flip it from the focus being on the shortfalls of the NCR accused and putting it as a problem solving exercise for the hospital, hopefully, to and the board to be engaged in what really concretely has to happen for this person to get into the community and proceed forward, so that you're pinning the hospital down, hopefully, on what exactly they're looking at in terms of steps for concrete improvement in the disposition of the NCR accused.
that's a really important point. So let's put a pin in that, I say, Maya, because um, looking ahead, so when you're in the hearing room, looking ahead at next year can actually be a big part of the focus. It depends what you're trying to do.
Mhm.
You're both trying to get something for your client now, often, but not always. Sometimes you're having the hearing at a very bad moment in time for your client. You're not going to get anything better or more than where
Mhm.
they're at. You're just trying to keep them from losing whatever they have in that moment. But then you can look ahead and say, well, hey, like, if we come back next year, and this has happened, and this has happened, and this has happened, and they get out of seclusion by then, let's hope, or whatever's happening, then will you be in a position to recommend the next thing? And if they say yes, that will show up in the reasons, which are mandatorily promulgated. And when you come back next year, you can try and hold them to that and pitch that to the board. But that's many steps down the road. So I think we've done all we can here. Thank you, Maya.
All right. Thank you, guys. And we will continue then in next episodes.